Speaker, very little has been said about the bill that is before the House this afternoon. And as a result, my time will be very short. Much has attempted to be said about the amendments which are to be moved at committee stage, but as previous rulings have demonstrated, those are not what are before us right now. Now, if I could just take the House and my friend from the Martin Northeast for a second to the recent record. This is where I begin. You say that we would have failed the Merval assessment. That is the 6th Merval assessment, which is carded for February of 2026. Mr. Speaker, we will not fail that. And the reason we will not fail it is that we are moving expeditiously and carefully and thoughtfully to ensure compliance with the FATF recommendations and special recommendations, while at the same time doing as little damage to human beings who are operating within this jurisdiction, well, to the greatest extent possible. Now, I just want to remind our friends that I read into the record a plea. They had given up their hands. They had put their hands up. Surrender. That was their position. So when they describe us as failing, if we fail, we try. And we will not fail. Their approach was to write CFATF not once but twice. And what did they do? First time they begged, and then when there was a response saying, nope, they begged again. And the response then was, no, you will be evaluated come March 2026, come hell or high water. Faced with that, we have had no choice but to move forward and to move forward with expedition in respect of these matters which are before the House this afternoon. And I'm aware of all the discussions which have taken place. I just want to remind the House that the CFATF regulations came as part of a package of 3. 2 of those pieces passed, the miscellaneous provisions, that was the general compliance bit, and the anti-proliferation bit. We paused with respect to virtual assets. And why did we pause with respect to virtual assets? Because even then, as a government in place for 120 days, as opposed to one in place for 3,650 days, give or take a few, they had done nothing but plead. We were interested in fixing this problem. We took the decision then that we were going to, come hell or high water, we were going to meet our Merval requirement and pass. We paused because we recognized we had a problem. And consistent with the philosophy of the Prime Minister and this government, we attempted even then, as a government in place for 4 months, to seek as much consultation as we could possibly have done in what time was left of us. because and Mr. Speaker, the central bank governor met in the conference room at the Attorney General with the Minister of Justice, I believe, and with me, and all the technocrats. And not only did we meet with all the technocrats, we did something our friends on the other side never do. When they are confronted with criticism from the public, they giggle. They ain't right yet. Mm-hmm. That is their approach. Philosophy. What we did was to say, come and sit down, tell us what your problems are. And we met with them, from governor to minister to the Attorney General. We met with, all of us had a first meeting with them. We told them, we put our cards on the table, we said, compliance is a necessity. At the same time, we want to accommodate as much as possible, if it can be done, what you wish to do. And Mr. Speaker, it was out of that thing that we cannot speak about here, but that we may speak about in 20 minutes' time when we're in committee stage, because of the brilliant suggestion of my friend from the Martin Northeast. That thing, which we will not speak about now, that is the idea that came out of those consultations. And I interrogated it, although I'm not sure, I'm a little fearful now. I interrogated that suggestion. I said, is this going to fly with our Merval assessors? I read the language, and I was assured that it would. And that is why the amendment, of which I cannot speak, will be moved shortly. Mr. Speaker, my colleague has spoken about the recommendation 15, which is, of course, what is driving us today. Now, as a lawyer, I look at that recommendation and I studied it to determine how much flexibility we would have. And if you look at 15.3a of the recommendations of FATF, because they're the ones driving the show, they ask us really, I mean, the language is all there, but they ask us to identify and assess. That's all that is asked for in 15.3a. Now, as you come down, 15.3b Roman 2 describes the risk-based measures. So commensurate with the risk that you identify, because you are asked first to assess and identify, then you allocate resources to efficiently mitigate those risks. And in 15, jumping down from 13, 15 requires us to, that is where the licensing and regulation requirement comes in. But there are several aspects of compliance. And of course, if you ban activity, it is not a risk per se that you need to license or regulate. I think that is common and basic sense. So, no, of course I can't speak of that thing which I cannot speak. But insofar as you choose to engage in a discussion with persons, real human beings who are affected, and insofar as they bring problems to us, it is our duty on this side as legislators to listen, and to listen without the arrogance that came to define them. That arrogance. No, I have to say something, you know. And some of you all might get vexed with me. That arrogance wasn't always there. But a fish rottens from the top. And and the arrogance started, it begins in the person of a man who perhaps may not be here today, but resides in a place to the north of us, on a hill, and who feels now that he can have press conferences at his will, and makes his own office, the office of the former Prime Minister. And he's allowed himself and his cancer to go straight into Diego Martin Northwest and his colleagues.
Mr. Speaker.
All right, Attorney General, there's an objection to relevance. We could move on. I think we've made the point.
So, thank you, Mr. Speaker. As long as the point is made, I think the relevance is spoken. But the general point is that we on this side listen to real people. And in listening to those persons, we formed the view that a piece of legislation which we introduced in an effort to make a deadline they ran away from. Okay? A piece of legislation we introduced in order to meet a deadline, they had nothing to do with 2 letters, not 1. Sometimes you say, okay, I beg once as a young man, and that's okay, I'm off. But you beg twice, the answer is the same. We tried to meet that deadline. We discovered that the legislation was in need of reform and rewriting. We rewrote the legislation to a certain degree to meet the interests of those persons. I'm not talking about the thing that I should not speak about, but we did do that. We make no apologies for listening to persons. That legislation is, the legislation is here this afternoon, and we will amend it to take into account the views of persons who have expressed that they will be hurt. Our government will never say to persons in this society, you're in riot yet. That's for him and his leader. We will never say that. So we make no apologies for doing the people's business here. If it takes us until 4 o'clock in the morning to go through all of the amendments which are before us, if they want to sleep, refresh themselves, get some coffee, some Coke, some hot chocolate, some donuts, we will provide. And if we don't provide, I will provide. But, Mr. Speaker, we will do the government's business. We will do the people's business. We will not beg for time. We will meet our obligations. We will pass the Merval report. We will do right to our citizens, and we will not say you're in riot yet. Thank you, Mr. Speaker.